Welcome to Spiedel's California Minute. I'm your host, Catherine Sedan. This week, we're covering the recent decision by the U.S. Supreme Court not to review the Olsen case challenging AB 5. Spiedel's federal and California tax update is the best 8-hour update to prepare for tax season. Learn about election year tax bills and proposals, the new beneficial ownership reporting requirements, the latest IRC Section 174 research expense and research credit developments, using AI in your tax practice, and more. Get registered for a live seminar or webinar session at caltax.com. AB 5 was signed into law in 2019 and went into effect on January 1st, 2020, meaning that California now uses the ABC test for purposes of determining whether a worker is an employee or independent contractor for purposes of the Unemployment Insurance Code and various payroll taxes. Proposition 22 was approved by voters in the 2020 election and generally took effect on December 17, 2020, to allow app-based drivers to be treated as independent contractors, but requires the network companies that employ them to provide certain benefits to these drivers. There has been ongoing litigation regarding how these drivers should be classified for the period of time between AB 5 going into effect, which classified the drivers as employees because there was no exemption provided for app-based delivery drivers, and when Proposition 22 went into effect to treat them as independent contractors. The state and various cities are suing the ride-sharing and delivery app companies on behalf of the workers to get back wages, benefits, including sick time, retirement, etc., and impose penalties. Last week, the U.S. Supreme Court denied reviewing Olsen versus State of California, meaning that all affected workers will potentially get back pay but would be forced to claim unreimbursed employee expenses on their California returns. The decision means Uber, Postmates, and Lyft will have to pay back wages to tens of thousands of drivers unless a settlement is reached with California officials. Olsen is the Uber and Postmates lawsuit challenging AB 5 because it improperly singles out app-based drivers, but exempts, through subsequent legislation, many other industries. Postmates was acquired in 2020 by Uber after the Olsen case was originally filed in 2019. Uber argued that it had been denied equal protection of the law because the exemptions under AB 5 were granted to referral services like those offered by WAG, which connects dog owners with dog care providers the same way Uber connects drivers with people who need rides. On June 10, 2024, in a unanimous en banc decision of the U.S. Ninth Circuit Court of Appeals, the court held that AB 5 did not violate app-based drivers' right to equal protection because there were plausible reasons for treating transportation and delivery referral companies differently from other types of referral companies. Uber and Lyft argued that lawsuits seeking back payments were invalid because the affected workers had signed arbitration agreements. But a California appeals court judge ruled in September 2023 that California officials were enforcing state labor laws and not suing on behalf of workers, meaning the arbitration agreements drivers signed are irrelevant for the purposes of these lawsuits. This is the second case regarding AB 5 that the U.S. Supreme Court has declined to review. In June 2022, the Supreme Court denied review of the California Trucking Association's case against the application of AB 5 and the ABC worker classification test to the trucking industry. To stay up to date with California tax law changes, subscribe to Spiedel's California Tax Letter. This monthly newsletter is written by California tax pros for California tax pros in plain English with helpful examples and charts. For subscription information, go to caltax.com and click Publications. That's all for this week. Join us next time for another episode of Spiedel's California Minute.